Before we begin, a quick and important disclaimer. The following content is provided for educational and entertainment purposes only. This retrospective on historical legal practices and economic trends does not constitute legal, financial, or professional advice. Laws regarding domestic relations and matrimonial proceedings have undergone radical transformations since the era discussed, and the historical data presented should not be used as a basis for modern legal decisions. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified legal and financial professionals regarding their specific circumstances. In the autumn of 1929, as the ticker tape machines in Lower Manhattan began to stutter and fail, a different kind of crisis was brewing inside the Mahogany Road offices of the American legal elite. For years, the American divorce lawyer had been the silent architect of the Roaring Twenties social liberation. Business was booming. Divorce rates had been steadily climbing for decades, fueled by a post-World War I sense of autonomy and the emergence of the new woman. But within months of the Great Crash, the lucrative conveyor belt of marital dissolution ground to a violent halt. We are often taught that the Great Depression was a story of bank runs, dust bowls, and breadlines. But there is a hidden darker ledger held in the archives of the 1930s family court system. This is the story of the invisible divorce, a period where the American family unit didn't just fracture, it became a financial prison. Statistically, the narrative of the Great Depression offers a jarring paradox. In 1929, the United States saw approximately 1.66 divorces for every 1,000 people. By 1932, at the absolute nadir of the economic collapse, that number plummeted to 1.28. At first glance, a casual observer might assume that the shared hardship of the era brought couples closer together, forging a renewed sense of domestic solidarity in the face of national ruin. However, historical trends and case studies suggest a far more clinical and devastating reality. People didn't stop wanting divorces, they simply could no longer afford the exit fee. The divorce lawyer of 1930 found themselves in a unique, unenviable position, presiding over a population that was desperately seeking legal liberation but lacked the capital to pay the retainer. This deep dive into the legal landscape of the 1930s will uncover exactly how economic volatility dictates the boundaries of our most personal relationships. For the modern U.S. audience, living in an era of fluctuating interest rates, housing instability, and recession-core lifestyle shifts, understanding this history is vital. We are going to examine the mechanics of the poor man's divorce, the rise of the Reno divorce mill as a luxury export, and the specific ways in which the legal profession had to pivot to survive when their primary product, freedom, became a luxury good. By looking at these potential outcomes of extreme economic stress, you will gain a clearer perspective on how financial health is the true, unspoken foundation of the American legal family structure today. To understand the crisis the divorce lawyer faced in 1930, we have to look at the product they were selling in 1928. During the Roaring Twenties, divorce was becoming a socialized, albeit still scandalous, reality. In states like New York, the law was notoriously rigid, often requiring proof of adultery to grant a decree. This created a cottage industry for lawyers who specialized in staged raids. A lawyer would hire a photographer and a professional correspondent, usually a woman paid to be found in a silk robe in a hotel room with the husband, to provide the necessary evidence for a judge. This was a high-stakes, high-fee legal theater. When the market crashed, this theater collapsed. The middle class, who had previously been able to scrape together the $500 to $1,000 required for a contested or even a staged divorce, suddenly found their life savings evaporated. The lawyer's office, once a place of strategic negotiation, became a site of bartering. We have documented historical accounts of rural attorneys in the Midwest accepting bushels of apples, livestock, or even manual labor in exchange for filing domestic paperwork. But in the urban centers like Chicago and New York, the overhead of a law firm couldn't be sustained on produce. The result was a massive spike in desertion, or what social workers of the era termed the poor man's divorce. Men, unable to provide for their families and unable to pay a lawyer to legally dissolve their marriage, simply walked out the door and never came back. This created a secondary legal crisis for the lawyers who remained. A surge in abandonment, cases that offered almost no financial return for the attorney, as there were no assets to split and no alimony to be recovered from a ghost. However, where there is a barrier for the masses, there is often a loophole for the wealthy. This era saw the explosive growth of migratory divorce. If you were a lawyer in the 1930s with a high-net-worth client, you didn't fight the restrictive laws of the home state. You sent your client to Reno, Nevada. In 1931, in a direct attempt to stimulate its own failing economy, Nevada dropped its residency requirement for divorce to a mere 6 weeks. This created the Reno Cure. Divorce lawyers in New York and Los Angeles would partner with Nevada firms, creating a seamless pipeline for the elite. This historical trend highlights a recurring theme in American jurisprudence. During economic downturns, the legal system often bifurcates, offering expedited solutions for those with liquid assets while the impoverished are left in a state of legal limbo. The divorce lawyer of the Great Depression also had to deal with the grim reality of alimony jails. Before the collapse, alimony was a standard expectation in upper-middle-class settlements. But as unemployment hit 25%, thousands of men who had been ordered to pay alimony in the late 20s found themselves physically unable to comply. This led to a surge in contempt of court charges. Lawyers found themselves in a cycle of representing men who were being jailed because they couldn't pay, and representing women who were starving because they weren't receiving the court-ordered support. It was a lose-lose scenario for the legal profession. Many attorneys had to transition their entire practice toward debt collection or bankruptcy law just to keep their own lights on. As we move through this retrospective, we will analyze specific case studies of law firms that survived this transition by innovating their fee structures. Some introduced the concept of the installment plan for legal services, a radical idea at the time. Others moved toward collaborative models out of pure necessity, as neither party had the funds to sustain a protracted courtroom battle. These adaptations laid the groundwork for the modern no-fault movements that would eventually follow decades later, as the legal system realized that forcing impoverished people to remain legally bound was a recipe for social catastrophe. By the end of this 10-part masterclass, you will understand the profound link between the Dow Jones Industrial Average and the sanctity of the American home. You will see how the lawyers of the 1930s navigated a world where the law was static, but the economy was liquid, and how those lessons apply to the modern landscape of 2026. Whether you are interested in history, law, or sociology, this deep dive will provide you with a toolkit to recognize the warning signs of legal economic shifts before they happen. We aren't just looking at old court records. We are looking at the blueprint of how society reacts when the cost of living and the cost of leaving becomes unsustainable. To understand the mechanics of the Great Depression divorce lawyer, we must first confront the brutal reality of the legal market in 1930. The crash didn't just wipe out stock portfolios. It decimated the very concept of the retainer fee. For the average American lawyer specializing in domestic relations, the early 1930s represented a period of radical professional adaptation. Imagine if you are a lawyer in 1931, sitting in a high-rise office in downtown Detroit. Your overhead includes rent, a secretary, and a library of leather-bound case law. Before the crash, your waiting room was filled with middle-class couples who had the liquid capital to end their unhappy unions. Now that room is empty, or worse, it is filled with people who have lost everything and are seeking a way to legally detach from a spouse who represents an additional, unsustainable financial liability. Historical trends during this era show that as the national income fell by 50%, the cost of justice remained stubbornly high. In many jurisdictions, the basic filing fees and court costs for a divorce could range from $25 to $50, a staggering sum at a time when the average weekly wage for those lucky enough to have a job had plummeted to less than $20. This created a massive bottleneck in the American legal system. The divorce lawyer was no longer just a legal representative. They became a gatekeeper to a luxury service. When we examine case studies from this period, we see the rise of what social historians call the invisible divorce. This phenomenon occurred when a couple would effectively end their marriage, living in separate rooms or separate dwellings, but remain legally bound because they could not afford the lawyer's fee or the state's filing costs. The legal professional had to find a way to navigate this penniless landscape. Many attorneys turned to a system of predatory or, in some cases, surprisingly empathetic bartering. We have documented instances in rural communities where lawyers accepted everything from livestock to hand-stitched quilts in exchange for drafting a bill of complaint. However, in the urban centers of the United States, where the cost of living was higher and the legal culture was more rigid, the situation was far more dire. Lawyers in cities like Chicago or Philadelphia often had to take on hundreds of pro bono or low-fee cases just to keep their standing in the local bar association, hoping that these clients would return with paying work once the economy stabilized. This leads us to a specific high-stakes scenario that was common in 1932. Imagine a man named James, a former foreman at a steel mill who has been out of work for 18 months. He and his wife, Margaret, have reached a state of domestic warfare. They are living in a cramped apartment with Margaret's parents because they can no longer afford rent. James wants to leave for California to find work, and he wants a clean break. He visits a divorce lawyer, but the lawyer explains that under the current laws of their state, James must prove grounds such as cruelty or adultery. Furthermore, the lawyer requires a $75 retainer. James realizes that even if he sold every possession he owned, he could not raise that capital. The potential outcome here isn't a legal resolution. It is a social one. James chooses what was then known as the poor man's divorce. He simply packs a bag in the middle of the night and disappears. Desertion became the primary method of marital dissolution for the working class during the Great Depression. This created a massive vacuum in the legal industry. Lawyers who had previously made their living on domestic disputes found themselves chasing ghosts. The legal profession had to pivot. Instead of filing for divorce, lawyers began specializing in warrants for non-support. This was a grimmer, more aggressive form of legal practice. A wife who had been deserted by her husband would hire a lawyer, often on a contingency basis, promising a percentage of any recovered funds, to track the husband down and force him into court. This created a cycle of misery that the legal system was ill-equipped to handle. If the lawyer was successful in finding the husband, the court would order alimony or child support. But because the husband was often unemployed himself, he would fail to pay. This triggered the rise of the alimony jail. In states like New York, hundreds of men were incarcerated not for crimes, but for the civil offense of being unable to pay their former spouses. The divorce lawyer was the architect of this system, trapped between a client who needed money to survive and a defendant who had no money to give. For the modern audience in 2026, this historical trend serves as a stark warning. When the cost of legal services outpaces the median income of the population, the law ceases to be a tool for order and becomes a source of chaos. We see parallels today in the rising costs of legal representation and the barriers to entry for basic civil justice. In the 1930s, this pressure cooker eventually led to a total rethink of how the American family was viewed by the state. Lawyers began to argue that the high cost of divorce was actually a public health crisis, as it kept people in toxic or even violent situations purely because of their bank balances. Case studies from the Legal Aid Society, which saw its caseload explode during the Depression, show that lawyers were overwhelmed by domestic difficulty cases. In 1933 alone, the New York branch of the Legal Aid Society handled thousands of applications from women seeking help with desertion and non-support. The lawyers working these cases were often young, idealistic, and drastically underpaid, reflecting a shift in the legal profession from a pursuit of wealth to a form of social frontline work. They were dealing with the fallout of a society where the traditional family unit was being pulverized by economic forces beyond anyone's control. Step by step, the process for a lawyer during this time involved an agonizing search for assets that often didn't exist. First, the lawyer would conduct a thorough financial audit of the couple. In 1928, this might have involved looking at stock certificates and real estate deeds. By 1934, it involved checking if the family still owned a radio or a functioning automobile that could be liquidated to pay the court. Second, the lawyer had to navigate the grounds for divorce. Since irreconcilable differences didn't exist as a legal concept in most states, the lawyer had to manufacture or find evidence of fault. This led to a rise in perjured testimony and staged incidents, where lawyers would guide their clients on how to present a story of abuse or infidelity that would satisfy a judge, even if the real reason for the split was simply that the couple had been broken by poverty. This era of the invisible divorce and the alimony jail forced the American legal system into a corner. It proved that the law cannot maintain social norms if the economic foundation of those norms has collapsed. The divorce lawyer of the Great Depression was a man or woman standing in the wreckage of the American dream, trying to find a way to legally codify the end of a relationship for people who couldn't even afford to pay for the paper the decree was printed on. But as the 1930s wore on, a new phenomenon began to emerge, a way for the legal profession to turn this crisis into a specialized, high-end industry for those who still had a few dollars left in their pockets. While the masses were disappearing into the night or rotting in alimony jails, the elite were looking toward a small desert town in Nevada that was about to change the legal landscape of the United States forever. Why did the state of Nevada decide to gamble its entire reputation on the broken marriages of the rest of the country? And how did lawyers across the U.S. build a secret railroad to Reno? We are about to look at the rise of the divorce mill, where the 6-week residency became the ultimate luxury product of the 1930s. In the early months of 1931, as the United States began to realize that the economic downturn was not a temporary dip, but a generational collapse, the state of Nevada made a move that would fundamentally reorganize the American legal profession. This was the birth of the migratory divorce industry, a phenomenon where the divorce lawyer shifted from being a local courtroom advocate to something closer to a high-stakes travel agent and jurisdictional strategist. To understand this, we have to look at the legislative desperation of the era. Nevada was suffering, the silver mines were exhausted, and the livestock industry was failing. On March 19, 1931, the governor signed a bill that lowered the residency requirement for divorce from 3 months to a mere 6 weeks. This was a calculated economic stimulus package, and the primary beneficiaries were the lawyers who knew how to market it. For a high-end lawyer in an urban center like New York or Boston, this change was a lifeline. Imagine if you are a senior partner at a prestigious firm in 1932. Your corporate clients are going bankrupt, and your real estate deals have dried up. But you have a client. Let us call him Robert, a wealthy textile manufacturer, whose marriage has become a social and financial liability. In New York, the law only allowed divorce on the grounds of adultery. This would require Robert to hire private detectives, stage a hotel room raid with a paid correspondent, and endure a public scandal that would likely sink his remaining business interests. This is where the lawyer's role became sophisticated. Instead of fighting the rigid laws of the East Coast, the lawyer engineered a 6-week relocation. The Reno Trail was a meticulously planned legal operation. The lawyer's task was to coordinate a multi-state handoff. First, the primary attorney in the home state would vet a correspondent firm in Reno. This was a highly selective process because if the Nevada lawyer made a clerical error, the entire divorce could be ruled invalid back home, leading to potential charges of bigamy if the client remarried. The home state lawyer would then manage the financial logistics. The client didn't just go to Reno. They had to establish a credible, legal residency. This meant the lawyer had to provide a step-by-step checklist: opening a Nevada bank account, registering for a local library card, and ensuring the client was seen daily in public spaces like the Riverside Hotel or the local parks. Historical trends show that this created a specialized class of Reno lawyers, who did nothing but process out-of-state applicants. These attorneys would often meet their clients at the train station, acting as both legal counsel and social director. They understood that the 6-week stay was a legal fiction that needed to be maintained with absolute precision. If a client crossed the state line for even a few hours to visit California, the 6-week clock could be reset, and the legal fees would skyrocket. The lawyer's job was to be the warden of this temporary residency. This was the first time in American history that the legal profession used jurisdictional competition as a primary product. But the real legal genius happened in the paperwork. To ensure the divorce would be recognized back in the home state, the lawyer had to navigate the full faith and credit clause of the United States Constitution. This clause generally requires states to respect the judicial proceedings of other states. However, there was a catch. The Nevada court had to have jurisdiction over both parties. This led to the development of the notice of appearance strategy. The husband's lawyer in New York would coordinate with the wife's lawyer. The wife would hire her own attorney in Reno, often a colleague of the husband's lawyer, who would formally appear in the Nevada court. By doing this, both parties were legally present in the eyes of the court, making the decree much harder to challenge later. This was a high-level, collaborative legal dance that only the wealthy could afford. The cost of this Reno cure was staggering. Beyond the legal fees, which could easily exceed $500, the client had to pay for 6 weeks of room and board in Nevada. This led to the rise of the divorce ranch. These were working cattle ranches that pivoted to become luxury retreats for wealthy Easterners. A stay at a place like the Flying Me Ranch could cost $100 a week. When you account for the lawyer's retainer, the travel expenses, and the Nevada filing fees, a Reno divorce in 1933 could cost upwards of $2,000. In a year where the average American family was living on less than $20 a week, the divorce lawyer was effectively selling a premium, get-out-of-jail-free card that was entirely inaccessible to the general public. For the modern audience in 2026, this is a masterclass in how legal systems adapt to economic pressure. Just as we see modern companies moving their headquarters to specific states for tax advantages or legal protections, the 1930s divorce lawyer was an early pioneer of forum shopping. They realized that the law was not a fixed moral code, but a set of competing services offered by different states. This created a massive rift in American society. While the poor were being sent to alimony jails in the East because they couldn't afford to pay settlements or hire lawyers, the rich were being toasted at divorce parties in Reno, having legally severed their ties in less time than it takes to settle a modern insurance claim. Case studies from the Reno courts in the mid-1930s show a fascinating demographic shift. While the early adopters were the ultra-wealthy, the middle class began to try and emulate the trend. This led to a rise in cut-rate Reno lawyers who offered all-inclusive packages. These lawyers would arrange for cheap boarding house stays and expedited hearings. However, these lower-cost options were often legally precarious. If the home state lawyer didn't properly coordinate the notice of appearance, the spouse back home could later sue for a share of the assets, claiming they were never properly served. We have records of legal wars that lasted for decades because a budget lawyer in 1934 took a shortcut in a Reno filing. The success of the Nevada model caused a ripple effect across the country. Other states, desperate for the revenue that lawyers and wealthy travelers brought in, began to lower their own standards. Florida and Arkansas attempted to compete by shortening their residency requirements. This created a race to the bottom that horrified the legal establishment of the time. The American Bar Association held heated debates about the ethics of these divorce mills. They argued that lawyers were no longer officers of the court, but were instead helping to commodify the destruction of the American family. Yet, for the lawyers on the ground, this was simply a matter of survival. They were responding to a market demand that the restrictive laws of their home states refused to acknowledge. This era proved that when the law refuses to move with the social and economic reality of the people, the legal profession will find a way to bypass the law entirely. The 1930s divorce lawyer became a master of the loophole, an architect of the legal fiction, and a pioneer of out-of-state litigation. They proved that for a high enough fee, the rigid boundaries of state law could become as thin as paper. But as more people began to use these loopholes, the home states began to fight back. They started looking for ways to trap these renovate couples when they returned, using the very laws the lawyers thought they had escaped. This brings us to a critical turning point. What happens when the legal decree from one state meets the stubborn resistance of another state's judge? We are about to look at the War of the Decrees, where couples who thought they were legally free found themselves caught in a jurisdictional trap that could result in their second marriages being declared illegal and their children being declared illegitimate. How did the divorce lawyer of 1935 defend a client when the state of New York decided to ignore the state of Nevada entirely? The answer lies in a series of shocking Supreme Court battles that would redefine the power of the American lawyer forever. The year is 1935, and the American legal landscape has become a battlefield of conflicting state interests. To the divorce lawyer of this era, the United States was not a unified legal entity but a patchwork of feudal territories, each with its own weapons and its own walls. While Nevada was profiting from the influx of wealthy Easterners seeking quick dissolutions, the conservative legal bastions of the East Coast, particularly New York and North Carolina, were preparing a counteroffensive. This created a period of extreme professional risk for the divorce lawyer. If an attorney advised a client incorrectly, that client could return home from Reno only to find themselves facing a grand jury for bigamy, or seeing their new marriage declared a legal nullity. Imagine if you are a woman named Sarah living in 2026, looking back at your great-grandmother's legal journals from 1935. In those pages, you wouldn't find stories of emotional closure. You would find a survival guide for a jurisdictional war. Sarah's great-grandmother had traveled to Reno on the advice of a high-priced Manhattan attorney. She stayed the required 6 weeks, she obtained her decree, and she returned to New York to marry her second husband. But within months, her first husband, motivated by a combination of social spite and a desire to avoid paying the agreed-upon settlement, filed a lawsuit in New York. He argued that Sarah's great-grandmother had never truly intended to become a resident of Nevada. He claimed the divorce was a fraud on the court, and under New York law, he was still her legal husband. This was the nightmare scenario for the 1930s divorce lawyer. The collapse of the full faith and credit clause. This clause, found in Article 4, Section 1 of the U.S. Constitution, was designed to ensure that the public acts and judicial proceedings of one state were respected by all others. However, Eastern judges began to develop a lethal legal loophole known as the bona fide domicile requirement. They argued that if a person went to Nevada solely to get a divorce and intended to return home immediately after, they never established a true domicile. Without a domicile, the Nevada court had no jurisdiction. Without jurisdiction, The divorce decree was as worthless as the paper it was printed on. The divorce lawyer's role shifted from being a mere paper pusher to being a choreographer of intent. To protect their clients from these potential outcomes, lawyers had to create a mountain of evidence to prove that the 6-week stay in Reno was not a vacation, but a permanent move that just happened to be cut short. Step by step, the lawyer would instruct the client to perform a series of legal rituals. First, they had to resign from their local clubs and charities in New York. Second, they had to move their primary bank accounts to a Reno branch. Third, and perhaps most importantly, they were told to register to vote in Nevada. The lawyer would then preserve these records like gold. If the client was later challenged in a New York court, the lawyer would produce the Nevada library card and the Nevada voter registration as proof of an intent to remain, even if both the lawyer and the client knew it was a carefully constructed legal fiction. Case studies from the mid-1930s show how high the stakes were. In several high-profile instances, individuals who had remarried after a Reno divorce were actually prosecuted for bigamy. The lawyer's defense in these cases had to be airtight. They had to argue that the state could not look behind the face of a sister state's decree. This was a sophisticated, high-level constitutional argument that required the lawyer to be as much a scholar of federalism as they were a practitioner of family law. They were fighting for the very principle that a U.S. citizen had the right to move freely between states and bring their legal status with them. The financial burden of this war of the decrees fell heavily on the clients, but it also changed the way law firms operated. Because of the risk of a decree being overturned, lawyers began to insist on indemnity clauses in separation agreements. They would try to force the stay-at-home spouse to sign a document promising never to challenge the validity of the out-of-state divorce. However, these documents were often unenforceable. A lawyer in 1936 had to tell their client the hard truth. There is no such thing as a guaranteed legal outcome when two states are at war. The potential outcome was always a gamble, and the lawyer's fee was essentially the price of the best possible odds. This era also saw the rise of the special appearance. When a client went to Reno, their lawyer back home would often contact the other spouse's lawyer to negotiate a deal. The goal was to get the other spouse to hire a Reno attorney to make a special appearance in the Nevada court. By doing this, the other spouse was effectively saying, "I acknowledge this court has the power to judge me." Once both parties had appeared in the Nevada court, the divorce became significantly harder to challenge back home. The lawyers were essentially colluding across state lines to build a legal fortress around the divorce. This level of cross-state cooperation between rival firms was a historical trend that paved the way for modern, interstate legal practices. For the American public in 2026, understanding this struggle is essential to understanding the evolution of privacy and personal liberty. The 1930s divorce lawyer was at the forefront of the battle to decide who owns your marital status. You or the state you live in. If New York could tell you that you were still married despite what Nevada said, then your most personal identity was a prisoner of geography. The lawyers of this era were the ones who finally pushed these questions all the way to the Supreme Court. By the late 1930s, the tension reached a breaking point. The legal community was looking for a definitive ruling that would end the chaos. They needed to know if a person could truly be married in New York but single in Nevada. This wasn't just a philosophical question. It affected Social Security benefits, inheritance rights, and the legitimacy of thousands of children born to second marriages. The lawyer had to navigate a world where a client's entire life could be upended by a single judge's interpretation of the word intent. The War of the Decrees eventually led to the landmark cases of Williams versus North Carolina. Although these cases would be decided in the early 1940s, the legal groundwork, the arguments, and the sheer desperation of the litigants were all forged in the fires of the Great Depression. The divorce lawyer was the one who had to explain to a distraught mother that her children might be considered illegitimate because she hadn't stayed in Reno for quite enough months or hadn't joined the right Nevada church. As we move into the next part of this masterclass, we are going to look at the dark underbelly of this struggle. When the legal fees became too high and the jurisdictional wars too risky, some lawyers turned to a more sinister tool: the professional detective. How did the divorce lawyer of the late 1930s use a growing network of private investigators to create the evidence they needed? And what happened when those detectives started playing both sides? We are entering the era of the shadow bar, where the line between legal representation and organized surveillance began to disappear. Why did the most successful lawyers of 1938 have more in common with spies than with traditional attorneys? By 1938, the Great Depression had been the reality of American life for nearly a decade, and the legal profession had been forced to descend into a realm of tactical gray areas. The divorce lawyer was no longer merely a student of the law. They had become a coordinator of a vast, unofficial surveillance network. In states like New York, where adultery remained the sole statutory ground for the dissolution of a marriage, the lawyer's primary job was not to argue points of law, but to manufacture or capture a moment of moral failure. This gave rise to the shadow bar, a symbiotic relationship between high-end matrimonial attorneys and private investigation firms. For a modern observer in 2026, the level of systemic deception required to navigate the family court system of the late 1930s is almost unrecognizable, yet it forms the dark foundation of our modern investigative legal practices. Imagine if you are a woman named Sarah in 2026, digging through the digitized archives of a defunct law firm from 1938. You find a series of invoices that don't list legal research or court appearances. Instead, they list items like photographic plates, evening surveillance of the Commodore Hotel, and fees for a professional correspondent. In the late 1930s, if a client wanted a divorce and couldn't afford the 6-week Reno sabbatical, their only option was to provide the court with evidence of a specific act of infidelity. But because many couples were seeking a divorce by mutual consent, which was technically illegal under the doctrine of collusion, the lawyer had to act as a director of a clandestine play. The mechanics of this were chillingly precise. Step by step, the lawyer would orchestrate what was known as a staged raid. First, the attorney would hire a private investigator, often a former police officer who knew exactly what a judge needed to see to grant a decree. The cost for these services was a significant portion of the legal bill, often ranging from $10 to $20 per night of surveillance, a massive sum when millions were still struggling for basic necessities. Second, if no actual adultery was taking place, the lawyer would coordinate with a professional correspondent, usually a woman who made her living by being found in compromising but non-sexual situations for the sake of a flashbulb. The raid itself was a high-stakes legal ritual. The lawyer, the investigator, and often a few hired witnesses would wait in a hotel corridor. At a prearranged time, they would burst into the room. The investigator would trigger a massive magnesium flash, capturing a photo of the husband and the correspondent. The husband would pretend to be shocked, the correspondent would cover her face, and the lawyer would have the evidence required by the state. Historical trends show that by 1938, the New York courts were flooded with these identical cookie-cutter cases. Judges knew they were being lied to. Lawyers knew they were participating in a charade. But the economic and social pressure to allow people to move on from broken marriages was so high that the legal system looked the other way, provided the theater was performed correctly. However, this reliance on the shadow bar created a terrifying secondary industry, the legal double-cross. Because these private investigators held the keys to a client's reputation, they were perfectly positioned for blackmail. Case studies from this era reveal instances where investigators would approach the opposing party, offering to suppress the evidence they had found, or invent evidence that didn't exist for a higher fee. The divorce lawyer of 1938 had to be a master of risk management. They had to vet their investigators with the intensity of a counterintelligence officer. If an investigator turned, or if a witness recanted their testimony on the stand, the lawyer faced not only the loss of the case but potential disbarment and criminal charges for suborning perjury. For the American public in 2026, this highlights a critical historical trend. When the law becomes too rigid to reflect the actual needs of the people, it doesn't stop the behavior. It simply moves the behavior into the shadows. The divorce lawyer of the late 1930s was a direct product of this friction. They were operating in a world where the official law of the land was a lie, and the real law was a series of negotiated transactions between lawyers, PIs, and the unknown women in hotel rooms. This environment attracted a specific type of legal mind, one that was comfortable with ambiguity and skilled in the art of the setup. We can look at a specific case study from 1938 involving an attorney we will call Thomas. Thomas represented a wealthy industrialist whose wife refused to grant him a divorce. In this scenario, Thomas didn't spend his time in a law library. Instead, he spent weeks coordinating with a detective agency to track the wife's movements, looking for any sign of a friendship that could be characterized as an affair. When the surveillance yielded nothing, Thomas had to advise his client on the potential outcomes of a manufactured situation. This was the ethical precipice of the 1930s legal profession. Do you remain an officer of the court and leave your client trapped in a failed marriage? Or do you become an architect of deception to provide them with the freedom they are willing to pay for? The data from this period suggests that a significant number of lawyers chose the latter. The divorce mill wasn't just in Reno. It was in every major American city, operating behind the closed doors of respectable law firms. The fees for these services were structured to include the payouts for everyone involved in the charade. This led to a massive inflation in the cost of domestic legal services. For the working class, this meant that legal divorce was a mathematical impossibility. If you couldn't afford the PI and the correspondent, you couldn't get a divorce. This economic barrier reinforced the social divide of the Depression, where the wealthy could buy a fresh start, while the poor were forced into abandonment or domestic misery. Furthermore, the rise of the shadow bar changed the way lawyers interacted with each other. In many cases, the opposing lawyers were actually working together to ensure the staged raid went off without a hitch. This was the ultimate irony of the 1930s legal system. The adversarial model of the courtroom was replaced by a collaborative model of perjury. Lawyers would negotiate the evidence before the case ever went to trial, ensuring that both parties got what they wanted while the judge received the required amount of paperwork to justify the decree. It was a perfectly functioning machine of systemic dishonesty, fueled by the desperation of a population that the Great Depression had left with nothing but the desire for a new beginning. As 1938 bled into 1939, this culture of surveillance and manufactured evidence began to leak into other areas of the law. The techniques developed by divorce lawyers, the wiretapping, the hidden cameras, the use of professional honey traps, started appearing in corporate litigation and labor disputes. The divorce lawyer had inadvertently created a blueprint for the modern surveillance state. But as the clouds of World War II began to gather on the horizon, the focus of the American legal system was about to shift again. The legal profession was about to face a new challenge. What happens when the men who were being chased for alimony are suddenly drafted into the military? The next part of our deep dive explores the radical shift from the hotel room raid to the military tribunal. We are going to look at how the build-up to war created a new kind of legal immunity and how the divorce lawyer had to fight a new enemy, the U.S. Department of War. What happened to the alimony jails when the prisoners became soldiers, and how did a single act of Congress in 1940 almost put every divorce lawyer in America out of business overnight? The era of the soldier's divorce is about to begin, and the rules of the game are about to be rewritten by the drums of war. As the calendar turned to 1940, the American divorce lawyer found themselves standing on the precipice of a legislative earthquake that would effectively freeze the domestic legal system in its tracks. For a decade, these attorneys had navigated the crushing poverty of the Great Depression by bartering services, orchestrating staged hotel room raids, and managing the high-end pipeline to Reno. But with the passage of the Soldiers and Sailors Civil Relief Act of 1940, the federal government intervened in the lawyer-client relationship with a force never before seen in American history. This act was not merely a piece of wartime legislation. It was a total tactical reset for the matrimonial bar. It transformed the divorce lawyer from a pursuer of assets into a professional observer, locked out of the courtroom by the requirements of national defense. To understand the magnitude of this shift, imagine if you are a legal researcher in 2026 named Marcus, examining the digital case files of a mid-sized law firm from Philadelphia circa 1940. You notice a sudden, jarring cessation of activity. Hundreds of active files for non-support, desertion, and contested divorce simply stop moving. There are no court dates, no depositions, and no final decrees. Instead, you see a single repetitive document inserted into every file, the Affidavit of Military Service. This was the document that effectively silenced the divorce lawyer. Under the new law, before a lawyer could move for a default judgment against a spouse who failed to answer a summons, they had to prove to the court that the defendant was not in military service. If the defendant was in uniform, the case was stayed, meaning it was frozen in time, for the duration of their service plus an additional 60 days. The shield of the uniform, a legal fortress. The Soldiers and Sailors Civil Relief Act, SSCRA, created a shield that was impenetrable for the civilian divorce lawyer. The potential outcomes for a wife seeking support or a husband seeking a clean break were suddenly dictated by the Selective Service. Historical trends from 1940 and 1941 show that the divorce rate, which had begun to recover as the Depression eased, hit another artificial wall. This wasn't because people were happier. It was because the legal target had become untouchable. Consider a case study from early 1941. A lawyer represents a woman named Evelyn whose husband, a notorious alimony dodger from the mid-1930s, had finally been tracked down to a boarding house in New Jersey. Just as the lawyer prepares to file for a wage garnishment, The husband is drafted. The moment he puts on that uniform, he is protected by federal law. The lawyer can no longer seize his bank account, he cannot be jailed for contempt of court, and he cannot be forced to appear at a divorce hearing. For the lawyer, this was a professional catastrophe. The years of investigative work and the hundreds of dollars in shadow bar detective fees were rendered useless. The lawyer was forced to tell their client that the king's shilling had bought the husband a legal immunity that no private attorney could breach. The affidavit of military service, the new gatekeeper. Step by step, the daily routine of the divorce lawyer changed. They could no longer simply file a motion and expect a hearing. The process now involved a rigorous search of military records. Verification. The lawyer had to contact the War Department or the Navy Department to verify the status of the opposing party. The affidavit. A formal sworn statement had to be filed with every single civil action, stating whether the defendant was in the Army, Navy, Marine Corps, or Coast Guard. The stay mechanism. If the lawyer found that the spouse was in service, they had to apply for a stay of proceedings. This wasn't a dismissal but a legal limbo. The lawyer's fee clock stopped, the client's resolution was postponed indefinitely, and the legal system essentially admitted it was powerless against the needs of the military. This created a unique economic pressure on law firms. During the Depression, lawyers struggled because clients had no money. Now they struggled because the law itself prevented them from finishing the job. Many firms that had specialized in high-volume, low-cost desertion warrants went bankrupt in 1940 and 1941. They were replaced by a new kind of legal practice, the military dependency consultant. The rise of the dependency allotment. As the draft ramped up, the divorce lawyer had to pivot from litigation to bureaucracy. In 1942, the government passed the Servicemen's Dependence Allowance Act. This was the first time the United States government stepped in to directly fund the families of soldiers. For the divorce lawyer, this was a new, albeit smaller, revenue stream. Instead of fighting for alimony in a courtroom, they were now charging fees to help women navigate the complex paperwork of the Office of Dependency Benefits. Imagine the scenario. A lawyer who previously spent their days arguing before a judge now spends their days filling out Form 640 to ensure a soldier's wife receives her $28 a month, plus additional funds for children. The lawyer's role became that of a navigator through a burgeoning federal machine. They had to prove the validity of the marriage, a task that was often difficult if the couple had been separated or living in a state of invisible divorce during the Depression. The historical data shows that this led to a massive cleanup of the American legal record. Thousands of couples who had been informally separated for a decade suddenly needed their legal status clarified to qualify for government checks. The divorce lawyer of 1941 was less of a litigator and more of a historian, digging through the wreckage of the 1930s to find a marriage license that would satisfy the War Department's accountants. The defense plant divorce, a new economic divergence. While the soldier's divorce was becoming impossible, a different phenomenon was emerging on the home front: the defense plant divorce. As the United States transitioned into the arsenal of democracy, unemployment vanished. Millions of women entered the workforce in factories like Willow Run or the shipyards of Richmond, California. For the first time in their lives, these women had independent income. They didn't need a husband's support, and they didn't need to wait for a government allotment. This created a surge in what lawyers called economic autonomy cases. A woman working at a Boeing plant in 1942 could afford the high-end legal fees that were previously reserved for the wealthy. She could hire a lawyer to track down her missing husband, provided he wasn't in the military, and pay for a contested trial in cash. The divorce lawyer's office, once a place of somber bartering, became a site of rapid, cash-based transactions. This historical trend highlights a critical shift. The Great Depression ended not just with a war, but with the sudden financial empowerment of the female client. The JAG versus the civilian lawyer. The entry of the Judge Advocate General JAG Corps into domestic relations created a new competitive pressure. Soldiers could now receive basic legal advice for free within the military. A soldier in a camp in Georgia could consult with a JAG officer about his troubles back home in Ohio. This military lawyer would then write letters to the civilian lawyer, often invoking the SSRA to shut down any legal maneuvers. The civilian divorce lawyer was now in a two-front war. They were fighting the opposing spouse, and they were fighting a federally funded legal team that had the power to stop the clock on any case. This tension led to a period of extreme professional frustration. Lawyers who had survived the lean years of the 1930s by being aggressive and tactical were now told to wait for the peace. But as the deployments moved from training camps in the US to the battlefields of Europe and the Pacific, a new, even more complex legal problem began to emerge. What happens when a soldier, protected by the shield of the uniform, decides to use that same shield to start a new life overseas? As 1943 approached, the divorce lawyer was about to face the nightmare of the global abandonment. We are entering the era of the transatlantic legal crisis, where a simple Reno divorce seems like child's play compared to a case involving a soldier in London, a wife in Kansas, and a new fiancé in the South Pacific. How did the legal profession handle a world where your client's spouse was literally moving at the speed of war? The next part of our masterclass will reveal the shocking statistics of proxy marriages and the rise of the war bride litigation. We are going to look at how the divorce lawyer of 1944 had to become an expert in international law just to settle a basic child custody dispute. Why did the end of the war lead to the greatest spike in divorce in human history? And why was the American lawyer the only person prepared for the fallout? The transition from the economic paralysis of the 1930s to the chaotic mobilization of the 1940s represents the most radical pivot in the history of the American matrimonial bar. As we look back from the vantage point of 2026, we can see that the divorce lawyer of 1944 was no longer the desperate negotiator of the breadline era. They had become a high-speed logistics officer. Imagine a modern legal analyst named David in 2026. David is using artificial intelligence to cross-reference thousands of digitized letters from 1944. He finds a recurring pattern. The Dear John letter was not just a romantic tragedy. It was a legal trigger that set off a complex international chain reaction that the American legal system was fundamentally unprepared to handle. By 1944, the U.S. Great Depression had been technically eclipsed by the war effort, but the legal residue remained. The lawyers who had spent a decade helping clients hide from creditors were now helping them navigate a world where the primary witness in a divorce case might be stationed on an aircraft carrier in the Pacific or in a trench in Belgium. This created the era of the transatlantic legal crisis. For the divorce lawyer, the challenge was no longer about proving adultery in a local hotel. It was about the logistics of international service of process. Historical trends show that the most significant legal hurdle of this period was the proxy marriage and its subsequent dissolution. During the early years of the war, several states allowed soldiers to marry their sweethearts back home via proxy, a third party who stood in for the groom during the ceremony. This was a morale-boosting measure encouraged by the government. However, by 1944, many of these marriages, often entered into in a fever of wartime sentimentality, were failing. The divorce lawyer had to solve a unique riddle. How do you legally dissolve a marriage when the two parties have never actually stood in the same room as a married couple? Case studies from this era highlight the complexity. Consider a soldier named Arthur who married a woman named Jane via a proxy ceremony in Kansas while he was stationed in North Africa. 6 months later, Arthur writes a letter to a lawyer in his hometown, explaining that the marriage was a mistake and he has met someone else in London. The lawyer now faces a jurisdictional nightmare. Under the Soldiers and Sailors Civil Relief Act, Jane cannot move forward with a divorce while Arthur is in service without his explicit consent. But if Arthur wants the divorce, he has to find a way to sign legal documents in a combat zone. The lawyer becomes a coordinator with the International Red Cross and military postal authorities, trying to track down a client whose address is a generic army post office number that changes every week. Step by step, the lawyer's process for a wartime divorce involved a level of detective work that would baffle a modern practitioner. First, the lawyer had to obtain a special power of attorney from the soldier, often drafted on the back of a ration card or a piece of scrap paper, which then had to be verified by a commanding officer. Second, they had to navigate the conflict of laws. If the marriage happened by proxy in one state but the wife lived in another, which state had the power to end it? Third, the lawyer had to manage the financial allotments. If a divorce was granted, the wife would lose her government dependency check. Lawyers often had to advise their clients to wait until the war ended to finalize the paperwork, purely so the wife could continue to receive the $28 a month needed for survival. This led to a massive buildup of pre-filed cases, a legal powder keg waiting for the peace to be signed. While these international dramas were unfolding, the domestic legal market was being transformed by the defense plant divorce. In 1932, a lawyer's office was often a place of charity. In 1944, it was a place of high-volume business. Millions of women were working in defense plants, earning wages that gave them a level of financial autonomy unseen in American history. These women, often referred to as Rosie the Riveters, were no longer trapped in the invisible divorces of the Depression. They had the cash to pay a retainer up front. Imagine a scenario in 1944 where a woman named Martha, working 10-hour shifts at a munitions factory in Ohio, walks into a lawyer's office. She hasn't seen her husband in 3 years, and she has discovered through mutual friends that he has no intention of returning to her after the war. In 1934, Martha would have been forced to accept her fate because she couldn't afford a $5 filing fee. In 1944, she places $50 on the lawyer's desk and demands a quick resolution. The lawyer, however, has to explain the potential outcomes of the Soldiers and Sailors Civil Relief Act. Even with the money, the law was designed to protect the soldier. This created a professional friction where lawyers were flush with cash but legally handcuffed. This era also saw the rise of the evidence by mail strategy. Because physical surveillance was impossible for spouses overseas, lawyers began to rely heavily on intercepted letters. The shadow bar detectives of the late 1930s were replaced by postal censors and accidental disclosures. A soldier would mistakenly send a letter intended for a new friend in Australia to his wife in Topeka. The wife would take that letter to her lawyer, and it would become Exhibit A in a plea for a divorce based on extreme cruelty or desertion. The divorce lawyer had to become an expert in the rules of evidence regarding international mail and the privacy rights of military personnel. By late 1944, the legal profession was sensing a shift in the wind. The War of the Decrees from the mid-30s had taught them that the system could not handle a sudden surge in filings. Leading matrimonial attorneys began to hold informal conferences to discuss the post-war wave. They knew that when 12 million men returned home, the artificial stability of the wartime marriage would shatter. The historical data supports this. The pent-up demand for divorce, combined with the new financial independence of women and the psychological trauma of the returning veterans, was about to create a statistical anomaly. The divorce lawyer of 1944 was, in many ways, the most prepared professional in America. They had been hardened by the poverty of the Depression and sharpened by the jurisdictional complexities of the war. They were building the administrative machinery that would handle the 1946 spike, a year that would see nearly double the number of divorces compared to the pre-war era. They were moving away from the staged raid and toward a more clinical, bureaucratic approach to ending a marriage. The law was finally beginning to catch up to the reality that a marriage could not be sustained by geography or legislation alone. But as the troops began to board the transport ships to return to the United States, a new and darker legal challenge emerged. It wasn't about the wives at home or the new friends abroad. It was about the children. The Great Depression had created a lost generation of children in broken homes, and the war had only exacerbated the trauma. The divorce lawyer was about to face the most contentious battle of their career, the custody war of the returning hero. What happened when a returning veteran, hailed as a hero by the public, was labeled an unfit parent by a lawyer in a divorce court? How did the legal system weigh the service of a soldier against the stability of a home that had moved on without him? We are entering the most emotional and high-stakes chapter of this retrospective. The 1945 homecoming crisis is about to redefine the concept of the best interests of the child, and the divorce lawyer is the one who will have to break the news to the men who thought they were coming home to a life that no longer existed. The year 1945 remains one of the most volatile hinges in American history, particularly for the divorce lawyer who had spent the previous 15 years navigating the economic wreckage of the Great Depression. As the troop ships pulled into New York Harbor and San Francisco Bay, the legal profession braced for a collision between the romanticized ideal of the returning hero and the cold, hard reality of domestic displacement. During the 1930s, the divorce lawyer was a master of managing scarcity. By 1945, they had to become a master of managing trauma. This era birthed the modern iteration of the custody war, where the legal concept of the best interests of the child was forged in the fire of post-war disillusionment. To understand the gravity of this moment, we have to look at the specific legal strategies that emerged when millions of men returned to find that the families they left behind had moved on, matured, and in many cases, found a new kind of independence that left no room for the traditional patriarch. Imagine if you are a researcher in 2026 named Jessica, looking through a pristine set of court transcripts from a 1945 custody hearing. You would see a narrative that feels hauntingly modern yet rooted in a specific historical desperation. In these files, the primary weapon was no longer the evidence of a staged hotel room raid or a 6-week Reno residency. Instead, the weapon was the psychological fitness of the veteran. For the divorce lawyer, The challenge was to balance the social pressure to honor the soldier with the legal obligation to protect the stability of the home. This led to a historical trend where the courtroom became a site of deep psychological interrogation, years before the term post-traumatic stress disorder even existed. Consider the case study of a veteran we will call Sergeant Michael. Michael returned to his suburban home in late 1945 after 3 years in the Pacific. He expected to resume his life exactly where he left it in 1942. However, his wife Linda had spent those 3 years working in a munitions plant, managing the family finances, and raising their young son, Tommy, without Michael's input. Linda had filed for divorce 3 days after Michael's discharge. In this scenario, Michael's lawyer had to rely on the traditional legal framework, that the father was the natural provider and the head of the household. But Linda's lawyer countered with a strategy that would redefine family law for the next century. They argued that Michael was a stranger to his son. They presented evidence that Tommy did not recognize his father and that Michael's war nerves, what we would now call trauma, made him a volatile presence in a stable female-led household. The divorce lawyer of 1945 had to navigate a massive cultural shift in the definition of the tender years doctrine. Originally, this doctrine suggested that young children, particularly during their infancy and early childhood, belonged with the mother for their emotional well-being. During the 1930s, this was often a secondary concern to the sheer survival of the family unit. But in 1945, lawyers began to use this doctrine as a defensive wall against returning soldiers. They argued that the child's best interests were served by maintaining the status quo of the wartime home. This forced the lawyer for the veteran into a defensive crouch, trying to prove that military service was not a disqualification for parenthood. Step by step, the legal process in these 1945 custody battles became increasingly clinical. First, the lawyer would call for a social investigation. This was a relatively new tool in the matrimonial lawyer's kit. They would bring in social workers or community leaders to testify about the atmosphere of the home. Second, the lawyer would use the financial stability of the mother as evidence of her fitness. During the Depression, a woman without a husband was often seen as a ward of the state. By 1945, a woman with a steady factory job and a savings account was a formidable legal opponent. Third, the lawyer had to address the elephant in the room: the veteran's mental state. Lawyers would often subtly, or sometimes overtly, suggest that the violence of the war had rendered the father unfit for the delicate task of child-rearing. The statistical data from this period is staggering. In 1946, the United States saw a divorce rate of roughly 18 per 1,000 married couples. This was the highest rate ever recorded in the country up to that point, a peak that would not be eclipsed for decades. The divorce lawyer was the primary beneficiary and the primary casualty of this surge. While their offices were full of paying clients, thanks to the post-war economic boom, they were also dealing with the human fallout of a society that was fracturing at the seams. The lawyers who had spent the 1930s bartering for apples were now negotiating for the custody of children in the most prosperous country on earth. For the modern audience in 2026, this history is a reminder that legal definitions of the family are always in flux. The 1945 divorce lawyer was the one who truly killed the 19th century concept of the father as the absolute owner of his children. By arguing for the child's emotional and psychological well-being over the father's traditional rights, these lawyers paved the way for the modern family court system. But they did so at a tremendous cost. They created a system that was inherently adversarial, where a hero's service could be turned into a liability, and a mother's independence could be used as a sword to sever the bond between father and child. Historical trends also show that this era saw a massive professionalization of the matrimonial bar. Lawyers began to specialize exclusively in domestic relations, rather than taking it as a side business to corporate or criminal law. They formed their own associations and began to lobby for changes in the law that would make the process less about fault and more about dissolution. They realized that the old system, the staged raids, the Reno trips, the private detectives, was too slow and too ugly for the fast-paced suburban world of the post-war era. They needed a more efficient way to process the sheer volume of marital failure. However, the shadow of the Great Depression still loomed large over these proceedings. Many of the judges sitting on the bench in 1945 had presided over the alimony jails of 1933. They were skeptical of any legal move that might leave a woman and her children dependent on the state. This led to a paradoxical outcome. While it became easier to get a divorce, it became much harder for men to escape their financial obligations. The divorce lawyer had to explain to the returning soldier that even though he was no longer a husband, he was still a permanent debtor to the court. The financial independence that women gained in the defense plans was often used as a baseline for child support, rather than a reason to waive it. Imagine the scenario. A lawyer sitting in a smoky office in 1946, looking at a veteran who has just been told he will only see his children every other weekend and must pay a third of his paycheck in support. The veteran asks, "What did I fight for?" The lawyer, hardened by the cynicism of the 1930s and the pragmatism of the 1940s, simply slides the decree across the desk. The lawyer's job was not to provide moral closure. It was to provide a legal exit. This professional detachment became the hallmark of the successful divorce attorney. They were the architects of the new American social contract, one where the individual's right to happiness was increasingly placed above the stability of the institution of marriage. But as the 1940s drew to a close and the 1950s suburban dream began to take hold, the divorce lawyer faced one final unexpected challenge. The society that had just seen a record-breaking divorce spike suddenly decided it wanted to go back to normal. The cultural pendulum swung toward the ideal of the nuclear family with a ferocity that made the divorce lawyer a social pariah once again. The legal profession had to go underground, hiding behind the white picket fences of the Eisenhower era. What happens when a society tries to legislate its way back into a dream that has already been shattered? As we move into the penultimate part of our masterclass, we will look at the era of the secret divorce, where lawyers had to invent entirely new ways to dissolve marriages in a country that was obsessed with looking perfect. Why did the most successful divorce lawyers of the 1950s become travel consultants to Mexico? And how did a single legal loophole in Juarez create a multi-million-dollar industry that almost destroyed the American court system? We are entering the world of the quickie divorce, and the stakes have never been higher. By the late 1940s and early 1950s, the American divorce lawyer found themselves navigating a culture that was suffering from a profound case of social amnesia. The United States wanted to forget the breadlines of the 1930s and the trauma of the 1940s, replacing them with a carefully manicured image of domestic perfection. However, the legal reality was that the cracks in the American family unit, first widened by the economic volatility of the Great Depression, had not disappeared. They had simply been paved over with suburban asphalt. For the lawyer of this era, the business of divorce became an underground operation. If the 1930s was the era of the poor man's divorce and the 1940s was the era of the soldier's divorce, the 1950s became the era of the quickie divorce. Imagine if you are a legal historian in 2026 named Alex, utilizing high-speed digital rendering to reconstruct the ledger of a prominent Manhattan law firm from 1952. You would notice a strange geographic anomaly. While the firm was based in New York, a staggering 40% of their domestic case files ended not in a local courthouse or even in Reno, but in a small border town in Mexico called Ciudad Juarez. This was the Juarez loophole, a multi-million-dollar industry that became the ultimate escape hatch for a society trapped between restrictive domestic laws and a desperate need for personal liberation. To understand why this happened, we have to look at the historical trends of the post-war period. After the divorce spike of 1946, conservative legislators across the United States tightened the screws. In states like New York, the law still required proof of adultery. The staged raids of the 1930s were becoming increasingly dangerous for lawyers as judges began to crack down on perjury. Reno, while still an option, required 6 weeks of residency, a time frame that was increasingly difficult for a new generation of corporate workers and suburban mothers to manage. The market demanded a faster, more discreet product. The divorce lawyer, ever the entrepreneur of human misery and hope, looked south. The mechanics of the Mexican quickie divorce were a masterpiece of jurisdictional arbitrage. Step by step, the U.S. lawyer would coordinate a process that felt more like a travel itinerary than a legal proceeding. First, the lawyer would establish a relationship with a Mexican correspondent attorney in Juarez. These Mexican lawyers were often highly efficient specialists who could process dozens of cases a day. Second, the U.S. lawyer would prepare the client for a 24-hour trip. The client would fly to El Paso, Texas, cross the bridge into Juarez, meet their Mexican counsel and appear before a judge. Third, because the state of Chihuahua allowed for divorce by mutual consent with virtually no residency requirement, the decree could be issued in a matter of hours. The client would be back in the United States by dinner time, legally single, or so they were told. Consider the case study of a woman named Susan in 1953. Susan was a mother of two in Connecticut whose husband had abandoned the family for a new life in California. A classic echoes of the Depression-era desertions. Susan wanted to remarry, but her husband refused to participate in a lengthy East Coast legal battle. Her lawyer suggested the Juarez option. For a fee of approximately $500, which included the lawyer's cut, the Mexican filing fees, and the round-trip airfare, Susan could obtain a decree without her husband ever setting foot in a courtroom. The potential outcomes of this strategy, however, were a legal minefield. This created the great constitutional crisis of the 1950s divorce lawyer, the doctrine of comity. Unlike the full faith and credit clause, which requires states to respect each other's laws, comity is the voluntary recognition of the acts of a foreign sovereign. U.S. lawyers had to warn their clients that while a Mexican divorce was fast, its validity was not a given. If Susan returned from Juarez and remarried, her first husband could potentially sue her for bigamy or challenge her right to his estate years later, claiming the Mexican decree was invalid under U.S. public policy. The 1950s divorce lawyer had to become a master of the bilateral appearance. They realized that a mail-order divorce, where neither party went to Mexico, was almost certainly void in the United States. To protect the client, the lawyer had to ensure that at least one party physically appeared in Juarez, and that the other party signed a formal power of attorney, acknowledging the Mexican court's jurisdiction. This created a high-stakes paper trail. Lawyers would often keep these files in private vaults, knowing that their clients' entire lives depended on the thin thread of a Mexican judge's signature, being respected by a skeptical American magistrate. Historical data from the mid-1950s shows that Juarez was processing upwards of 15,000 divorces a year for Americans. This was no longer a niche service for the elite, it was a middle-class survival strategy. The lawyers who facilitated these trips were often walking a professional tightrope. The American Bar Association viewed these divorce mills with extreme hostility, seeing them as a subversion of the dignity of the law. Yet, for the lawyer on the ground, they were providing a necessary service for a population that was still feeling the long-term domestic effects of the Depression and the war. Imagine a scenario where a lawyer named Richard is sitting in a smoke-filled office in 1954. He is explaining to a client that a Reno divorce is the gold standard, but the Juarez divorce is the economy class. He has to explain that if the client chooses Mexico, they must never ever move to a state like North Carolina, where the courts were notoriously aggressive about overturning foreign decrees. The lawyer wasn't just a legal advocate, they were a geographical strategist, mapping out which states were safe for a person with a Mexican decree and which states were danger zones. This era also saw the rise of the proxy divorce scandal. Some unscrupulous lawyers began offering divorces where neither party had to travel at all. They would simply send the paperwork to a contact in Mexico, who would return a signed decree for a small fee. This was the ultimate realization of the commodification of the law that began in the 1930s. When these mail-order divorces began to be challenged in U.S. courts, the lawyers involved faced disbarment and criminal prosecution. It was a stark reminder that even in an era of suburban conformity, the legal system had its limits. For the audience in 2026, the Juarez era serves as a fascinating precursor to our modern world of destination legal services. It was the first time that the American middle class realized they could simply leave the country to bypass laws they didn't like. The divorce lawyer of the 1950s was the architect of this international bypass, turning the border into a legal filter that allowed the unhappy to escape while maintaining the illusion of domestic stability back home. But as the 1950s drew to a close, the sheer volume of these quickie divorces and the constant legal battles over their validity began to break the system. The American legal establishment realized that they could no longer ignore the reality of marital breakdown. The friction between the law on the books and the law in action had become too great. The stage was being set for the most significant revolution in the history of the American family: the move toward no fault. The transition from the shadow bar of the 1930s and the Juarez flights of the 1950s leads us to our final destination. We are about to look at the birth of the modern era, where the divorce lawyer finally stepped out of the shadows and into the mainstream of American life. How did the lessons of the Great Depression finally convince lawmakers to stop treating divorce as a crime and start treating it as a civil right? We are entering the endgame of this retrospective, where the legal profession finally achieves the California dream of 1969. In the final part of our masterclass, we will reveal the secret connection between the Reagan administration and the total dismantling of the fault-based system. Why did the man who championed traditional values become the one to sign the law that put the old-school divorce lawyer out of business forever? The revolution is coming, and it starts with a single pen stroke in Sacramento. The pen stroke that occurred in Sacramento in 1969 was not just a legislative update. It was the final, formal surrender of a legal system that had been in a state of undeclared war with the American public since the Great Crash of 1929. When Governor Ronald Reagan signed the Family Law Act of 1969, he effectively dismantled the high-stakes, adversarial theater that the divorce lawyer had been forced to master during the Great Depression. As we look back from the year 2026, we can see that this moment was the direct result of 40 years of systemic failure. The legal profession had spent decades trying to maintain a 19th-century moral standard in a 20th-century economic reality, and the result was a culture of institutionalized perjury and jurisdictional chaos. Imagine if you are a modern legal analyst in 2026 named Marcus. You are looking at the historical trends of the 20th century, and you notice that the most significant drop in legal fees and the most significant rise in civil efficiency occurred right after the move to no-fault. For the first time, a divorce lawyer did not have to hire a private investigator to stage a hotel room raid. They did not have to coach their clients on how to lie under oath about adultery. They did not have to coordinate a 6-week residency in Reno or a 24-hour flight to Juarez. The lawyer's role shifted overnight from a director of legal fiction to a manager of financial distribution. To understand the magnitude of this shift, we must look at the specific mechanics of the Family Law Act. Before 1969, a divorce lawyer had to prove a crime. Divorce was essentially a civil prosecution where one party was the victim and the other was the villain. This was the fault system that had turned the Depression-era lawyer into a detective and a strategist. Step by step, the 1969 law removed these requirements. First, the term divorce was replaced with dissolution of marriage. Second, the requirement for grounds like adultery or extreme cruelty was replaced with a single neutral statement: irreconcilable differences which have caused the irremediable breakdown of the marriage. Third, the lawyer's primary task moved from proving wrongdoing to calculating the equitable division of community property. Historical trends show that this change was a direct response to the invisible divorces and the poor man's divorces of the 1930s. Legislators finally realized that if you make the legal exit too expensive and too difficult, people will not stay married. They will simply walk away, creating a social mess of abandoned families and illegitimate children. The 1969 revolution was the culmination of the lessons learned when the Great Depression proved that the state cannot legislate a marriage into existence when the economic foundation has collapsed. The divorce lawyer of the 1970s became a professional who processed reality rather than one who manufactured a narrative. Consider the case study of a legacy law firm that had survived from 1929 to 1979. In 1934, the firm's lead attorney, whom we will call Thomas, spent most of his time vetting professional correspondence and negotiating with private eyes in the shadow bar. His files were filled with photographs of hotel rooms and transcripts of intercepted letters. Fast forward to 1974, and Thomas's son, practicing in the same office, spent his time looking at tax returns, pension valuations, and real estate appraisals. The potential outcomes of a case were no longer determined by who could tell the most convincing lie in front of a judge, but by who had the most accurate financial data. The alimony jails of the 1930s were replaced by standardized child support tables and spousal maintenance formulas. However, for the divorce lawyer, this transition was a double-edged sword. While it made the process more humane for the public, it also democratized the legal industry in a way that reduced the premium on high-end strategic maneuvers. In the 1930s, a divorce lawyer was a magician who could find a loophole in a restrictive state law. In the 1970s and 80s, the lawyer became an administrator. This is why many of the old-school matrimonial attorneys fought against no-fault. They knew it would end the era of the $1,000 retainer for a staged raid. They were losing their status as the gatekeepers of a luxury service. For the modern audience in 2026, this retrospective provides a vital toolkit for understanding how the law reacts to extreme economic volatility. We have seen through this 10-part masterclass that when money disappears, the law must become more flexible or risk becoming irrelevant. The Great Depression forced the divorce lawyer into the shadows, the World War II era forced them into international logistics, and the post-war boom forced them into psychological warfare. Each of these eras added a layer to the modern legal professional we see today. Today, in 2026, we see the final evolution of these historical trends. We have moved from the shadow bar of 1938 to the digital dissolution of the current year, where AI-driven mediation tools are doing what once took a team of lawyers and investigators months to achieve. But the core tension remains the same. How does the legal system handle the end of a partnership when the financial stakes are high and the emotional stakes are higher? The divorce lawyer of the Great Depression was the first to realize that in a capitalist society, the marriage contract is as much a financial agreement as it is a romantic one. They were the ones who had to navigate the bank failures, the breadlines, and the desertion warrants to keep the legal machinery running. By examining these case studies, we can see that the potential outcomes for any legal system are always tied to the health of the economy. When the U.S. audience looks at their own legal challenges today, they are seeing the ghost of 1932. The barriers to entry for legal services, the rising costs of representation, and the complexity of jurisdictional disputes are all issues that were first faced by the lawyers who sat in those mahogany road offices during the Great Crash. They were the pioneers of the Reno Cure, the Juarez Quickie, and the no-fault revolution. As we conclude this deep dive masterclass, it is clear that the divorce lawyer of the Great Depression was not just a participant in a social crisis. They were the architects of the modern American family's legal exit strategy. They proved that even in the darkest economic times, the human desire for a fresh start is a powerful market force. They showed us that the law is not a static monument, but a living, breathing, and often desperate response to the world around it. We are the inheritors of their loopholes, their strategies, and their hard-won legislative reforms. But the story of the Great Depression and the law does not end with the family court. The same economic forces that fractured the home also transformed the way we protect our assets, our businesses, and our very identities. The divorce lawyer was just the beginning. As the 1930s drew to a close, a new kind of legal specialist was emerging. One who would take the surveillance techniques of the shadow bar and apply them to the largest corporations in the world. What happens when the same private investigators who were raiding hotel rooms in 1938 are hired to protect the industrial secrets of the 1940s? We are about to pivot from the bedroom to the boardroom. Our next deep dive will uncover the hidden history of the corporate spy during the rise of the American military-industrial complex. Why did the skills of a divorce lawyer become the most valuable asset for the CEOs of the Cold War? The trail of the shadow bar leads somewhere much darker than a Reno ranch, and you won't want to miss the first part of this new investigation.